Question for you. How does the breaking news about an Obama-appointed judge blocking oil exploration on 500 square miles of federally owned land in Wyoming because he says he fears climate change actually give us an opportunity to get over the frustration about this climate change cultist and learn some timeless, possibly very important lessons about the Constitution, about federal land claims, and even about so-called tort law? Hi everyone, I'm Gardner Goldsmith for MRC-TV. And yes, indeed, on March 19th, Obama-appointed Judge Rudolph Contreras blocked the Trump administration from allowing oil exploration on 500 miles of federally owned land in Wyoming. His reason? Well, very sensible. Fears over anthropogenic climate change. Why not? Yes, indeed. The case was called, get this, Wild Earth Guardians et al. Versus Zinke et al. And the ruling was for summary judgment. In fact, right at the start of the ruling, we got an idea of where the judge was coming from. Quote, climate change and humanity's ability to combat it are increasingly prominent topics of public discourse. End quote. And of course, the court doesn't mean naturally occurring climate change, which is most closely correlated to solar variation. What the court means is, yeah, you got it, anthropogenic climate change, which is theoretical, politicized, and unproven. And of course, the ruling was also partly based on a 2007 U.S. Supreme Court ruling called Massachusetts versus EPA, a ruling in which the Supreme Court said that the EPA had to regulate carbon dioxide as a pollutant. Yes, indeedy. So, Contreras' court used that to conclude, given the national cumulative nature of climate change, considering each individual drilling project in a vacuum deprives the agency and the public of the context necessary to evaluate oil and gas drilling on federal land before irretrievably committing to that drilling. End quote. Which, of course, leaves some people questioning whether or not this judge really knows what he's talking about, because the exploration for oil is not the burning of the fossil fuels, unless one were to think that he's actually talking about the burning of the fossil fuels for the machines to find the oil on that land in Wyoming. But regardless of that, it seems that the intent of the judge is very clear. The judge wants the EPA to put the brakes on further oil exploration and to put the brakes on a decrease of our overall energy expenses. And as Alex Newman writes for The New American, sensible voices have expressed hope that the bizarre ruling will be overturned, but critics of the ruling said the Trump administration must take urgent action or risk further rulings like this. End quote. And such thoughts are very valuable and warranted, but I think they merely tinker around the edges of the core of the problem, which comes, I believe, in three places. First, there's the fallacious notion of federal lands themselves. The Constitution actually only grants the federal government the power to control three types of land. The first is Washington, D.C. The second are federal garrisons for federal troops. And the third are federal territories. When territories become states, they're supposed to enter the Union with all the rights and privileges of any state. And there is no provision in the Constitution that requires any state to cede land to the federal government. Even if there were, there's no provision in the Constitution that gives the federal government any sort of power to manage such land. So that means that federal parks, federal monuments, and yes, this land in Wyoming are supposed to be left up to the states, better yet, left up to individuals to buy and manage according to how people actually value them. This is very important to consider. Unless we allow people to own private property, we don't know how people want that land managed. It's possible that people might not want drilling on the land. Maybe they would want it for natural wonders. We can't tell because the federal government owns it and rents it out. In addition to that, if we had a private property paradigm, that would open up private property tort claims on a real tort level. And what do I mean by torts? That goes back to ancient common law. A tortious claim is a claim for damages to yourself or your property. And the idea was that if you could show that you had been damaged or your property had been damaged, you could go to court and sue for restitution. Nowadays, the federal government steps in before anyone has been damaged, or the federal government itself claims damages, and that's impossible because the government is not a person. The EPA is not an individual and has no standing in common law tort concepts. So, the way to fix this and have real environmental management is to allow for private property to be owned and get it out of the federal government's hands. In addition to that, if someone were to claim that the use of the fossil fuels were causing them damage because of anthropogenic climate change, then they could bring a suit for damages. Of course, I think that would be very difficult to prove. So what are the takeaways from this? Well, yes, frustration over an Obama-appointed judge, but maybe a little something else that we can remember over time and tell our friends. We can tell them the federal government has no role in controlling these lands, and in doing so, messes up the very valuations that are required to tell how the land should be used, and finally, destroys the concept of real tortious claims. Very simple. Very easy, and something we can pass along to other people anytime. Thanks so much for watching. Don't forget to like and subscribe for MRC-TV. I'm Gardner Goldsmith.